I'm wired in, so I'm not sure.
I'm wondering if we should, because we have so much stuff, we should pull this over.
Yeah, how I finagled that. It was my gift, my sign, like when I get really still.
Okay, these are.
We had no idea what that was.
Burning tag.
Burning tag. All we could picture was like flames going up everywhere in our presentation.
You did the timing last night, and things were okay.
It's not, that's fantastic.
This is like I always find this. Hey, Joe.
Well, right. I mean,
We have dinner with you last
Nobody sits Johnny in the corner.
You have a lavalier and a handheld filter?
Yeah. Yeah.
So can I do this? Can you do this? Were you with this?
So awful. I already tore down the flag. Stay for that. It's not game stuff. I'd be having like a heart attack.
a couple nights ago, there were random
Oh, yeah? Be around. Oh, of course. No, yeah, that's possible too. You just hang out like outside.
It's like, you know, no, exactly. They've been selling it in the train station, like set up the unit there, right here. It's like you buy shirts like that. All right.
I checked when I found out it was Chicago, like, oh, forward.
Yeah.
And so we have like 5 people for dinner tonight. And just check how much standing room 485. I was like 45 for 5. And I was like, and no one cares for fucking me. Okay, we're not going in. Yeah. But I have to remember that it's, oh, there's your head.
Yes, sir. Well, you know, they're like, you're going to be in the first one, so you can far right chair. And we get started. All right. And then John and I will sort of wander around and people do their 6 minute things. If you want to stand up, you can. We have a handle. And I've got this one. This gives me power. I got to send you some. I got to have your attention. And it'll be great because a third of it will already be over by then. And they'll be really nervous because they missed a third that they didn't really look at.
Replacing, is Tanita coming at all?
Yeah, she's just cleaning herself up. She's just coming. But so we have me talking about my course, Judith talking about her course, and Sunrise.
Yeah. Oh, it needs a lot less, so. Interesting. Just You're awesome. You probably have the same challenge.
I can't do it.
Yeah.
No, I didn't. No, for once I got home, the sun was still up. Just happy to see daylight by the time I got home. Yeah. After the sunset.
Pretty good.
Yeah, I actually figured out a way to get it.
Yeah, I can get there.
Yeah, no, I tried that.
Oh, they did?
Well, there should be ways
Tired yet? I did tell you, but she thought you, she's gonna bring you over some good presentation. All right.
No,
Alright, we're gonna do like a cramped version of it. And I just saw Conrad, I told him to come here. He's probably out
First hour.
So, just a very short here. You guys have to get through. That's how it is. You don't like it? Is that enough? We have like 20.
We have a system. We are getting access.
Resupply hats every session.
No, ja, no.
Just take a picture of the crowd. We have a crowd,
We had a different one just, I think that was the last one.
Give me your email.
I'm sure you thought of it.
Won't be part of the official.
Take out your face.
I was gonna say, which one was like,
I know. No, we were telling like my family, we were telling friends, we were like, the hardest part is, but in order for people to even understand your process, you sort of have to like explain.
More and more people have it.
You know what the slip side? No. Were you ever altered one? It's just like the water. Sure, there was a name for it because there's a name for every device you can kept. My favorite was the incense.
Pick an end.
Did you get the slides?
Right over left. Left over right. The nuns would slap you if you did that. Oh. Then Vatican II and they used up so much food.
David? It says to be fine. My nose is working?
Yeah, I can see it. Yeah.
Welcome. Thank you. Nice to see everybody. Good morning. Good morning. I love that good morning thing. And I think it's a, like a cultural thing, but I love it. My name is Ron Stout, and I've been looking forward to this day for years. We have together today just a spectacular group of speakers who are gathered because they're participating in, or have participated in, two significant activities. We have 3 hours of presentation and discussion. Every hour session is set up to give you like 5, 4, 3, 4, 5 very short 6-minute kind of like thought starters from people who have spent a lot of time and energy thinking about the topic, and then to engage you. And I'm going to tell you, if you're not going to engage with us, we'll engage with each other, because we have dinner, we do stuff, we like each other, we have a lot to say. So if you don't want to talk to us, we'll talk to each other, and that will be good too. That will be interesting too. My part of this is, I sort of flip over on both, but my part of it that I'm standing up here today for is that I am one of the co-editors of the Chicago-Kent Law School Law Review Symposium called Justice, Lawyering, and Legal Education in the Digital Age. And we think this is the answer to many of the questions raised on Thursday morning and especially yesterday morning by Bill Henderson. And there's a copy of the book here for all of you if you wish to pick up one. John tells me people don't like that. Which is odd, because when you started this conferencing, you used to give everybody all kinds of books because you're a voracious reader. And even I think even Stanley Fish is saying throw away all your books and just look at stuff on digital format.
Do we have a Kindle version of that?
So we have 7 article authors represented in our array of presentations this morning in this track, and in addition we have a group of faculty members, some of whom overlap the author group, who John's going to tell you about. Cool.
Good morning. Good morning. My name is John Mayer. I'm the Executive Director of CALI, the Center for Computer Assisted Legal Instruction, and I'm a setup guy, right? So I do a little bit of setup. So you just heard about the symposium. The reason for CALI's involvement is that we got a grant along with the Center for Access to Justice and Technology here at Chicago-Kent. We should probably start using the acronyms. So CALI got a grant from LSC, a TIG grant, with CATJ to do this A to J project. And basically, basically, the idea here is this. We've written a piece of software called A to J Author, and I'll give you a little picture of that in a second. And there aren't enough authors in the world to automate all of the legal forms that need to be automated to even begin to deal with the justice gap. And the pool of authors that we want to grow is right in front of us. It's at the law schools and taking clinic courses at the law schools that are members of Cali. And so this project is to do a pilot with 6 schools on how they might integrate A to J Author into their teaching, and then inform us about features and functions, and we're going to create a website from that will then open up to all 200 schools, and actually it goes beyond 200 because I've got emails and interest from the folks who were here from Trinidad and Tobago and from Hong Kong and from even further places like Canada who want to do the same sort of things. They want to integrate, they want their students to learn how to automate legal processes to help help poor people, essentially. All right. So here are the three sessions for this morning. I'm not going to read the screen. You can see it on your own thing. But the first one will basically be the hybrid courses. The second one, will be the traditional clinic courses. The third will be sort of the wider perspectives on that. And this is what A to J Author is. I feel like I should give you like 1 minute on A to J Author in case you've never looked at it or seen it yourself. It's a graphical user interface. It's essentially a web-based form, but there's a lot of attention paid to making it easy to use for someone who is maybe English as a second language, maybe hasn't finished high school, maybe is afraid of technology, and more than likely is in a stressful situation because they have a legal problem, and they can't get access to legal aid, they can't get a lawyer. Many people, 80%, up to 80%, stand in line when the door closes to legal aid at the end of the day. And so their only alternatives, many of them, their only alternatives will be going to the web to find a solution. And hopefully there's a form that's been automated that might help them in their situation. And A to J Author is an attempt to solve some of those problems. All right? So this is what the authoring system looks like on the left. This is what it looks like to the user on the right at the top. And right now with A to J, you marry it with a document assembly system so that after the person fills out the forms, I always have to compare it to TurboTax. How many people do their taxes by hand? All right, so I'm using negative space there. So how many people use TurboTax, TaxSlayer, TaxAct? Yes, almost everybody. So A to J Author is like a TurboTax for all the rest of the forms in the world, in which the authors are the experts, legal aid people, or in this case, they'll be students working with legal aid attorneys to automate a particular process. Thank you. Pointed at the computer. I can't believe you're giving me technical support.
So awesome.
Or say, move the screen ahead.
Siri. That work?
It's better if you're closer to the PC.
Better if I'm closer. Thank you, Emily.
Go forward or back.
Arm's length.
All right, hit back once. All right, hit forward once. I wanted to make sure where I was. Right. So this is actually an old slide. A to J, the legal aid organizations have taken this up. They've automated well over 900, or well over 800 guided interviews that were used 500,000 times just last year, and 1.5 million times in the last 4 or 5 years. So that's huge. But it's not. It's it's a small bite out of a very big elephant. And the goal is, next slide. The goal is to create course materials from these people that will then be distributed to or made available for free for other law schools so that they could use them as a starting point to teach their own classes and their own students, so that we don't have dozens of authors, we have hundreds, or we have thousands. So we don't have 800 forms, we have 8,000 forms. We don't have 1 million usages, we have 100 million usages. And maybe some bigger bites out of that elephant of the justice gap. Too much of a metaphor there, right? Next one. So the cool, so what I love about this project is it's a quad factor win, right? Students pay tuition to learn a 21st century skill, which is how to automate a law process. The schools get a piece of software that's part of their Cali membership to do this. Legal aid gets help automating forms, and the public get the automated forms for their help. And that's win, 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 win. All right, next slide. I'm going to hand it off to Ron.
All right, so one of the things in Bill Henderson's blueprint for change, hey Bill, good to see you, long time. The blueprint for change is about collaboration, it's about collectives, it's about getting together and making stuff happen. And that's really what today is all about, is like bringing back to you some of the results of those collectives. And one of the most important people in the symposium side of this collective is Mark Lauritsen, who is our co-author, editor, and an author. And Mark just flew in from Rome from the AI and Law Conference to be here with us today, and he will moderate the next session. And the last session talked about his article, which is an interesting perspective on the First Amendment and other important issues that we're facing. I also have with me some people that collaborate with me, Andrew Medeiros, who helped me write the article, helped edit the symposium, and Jessica Frank, who is the director of our center here. So nothing happens without all these people helping us. So thank you. All right, so we're about to launch into sort of Ignite TED, sort of fire starter kind of presentations after this introduction. So thank you, John, for getting us started. The first of these sort of hybrid courses that was developed here. It's called the Justice and Technology Practicum course. We started teaching it in 2010, so we'll be teaching it for the 4th time this coming fall. It is a true hybrid. I used to be a clinical teacher 30 years ago, but I teach in the classroom now. I teach copyright law and public interest law, and in a very pretty traditional way, although there are projects and things going on in some of those courses. But I teach this course with a piece of that traditional style, the piece being a series of readings and presentations and guest speakers, some of whom you're going to hear from today, who are either appear in person or by Skype, and we raise and think about the issues that John has made us think about a little bit that are justice related, but also about issues related to the core function, the core competencies that students need to develop in order to be effective practitioners in this emerging digital world. So we look at traditional readings, and we have class discussions in much the way you would have class discussions in any traditional classroom course. In that context, we also assign projects to students that require legal research. For example, pick a simple one. Somebody wants to do automate the fee waiver petition in a local court. Well, they've got to go read the statute and analyze any case law about what makes somebody eligible for that process. But they also need to understand the procedure, and more interestingly, I think, from a sort of a quasi-clinical perspective, we push them into the environment, make them follow people around the courthouse as they try to get their fees waived on their own. Make them go to the court session where the judge decides whether or not that fee waiver is granted, and gather up from legal experts like Sunrise and others who are in the room, Joe and Conrad, people who are deep into practicing law, understand the heuristics of that process. And so they get a deep look at a particular process. In addition, they have to do a memorandum about that, a traditional legal writing exercise, a memorandum that will document that background of law, procedure, and heuristics to sort of audit the results that they're going to produce. Next, they do some field work. In addition to that following around, they sit in help desk settings where these kinds of tools that they're going to build are used by low-income people, and watch them do that effort. Watch them try to work through on their own a guided interview, or help them work as a navigator, work through a guided interview to understand the customer. You get a sense of the linguistic levels and the kinds of language that they understand, and the problems that they have using the tool, and how to deal with those problems. And then they dive into the technology. They write a hot docs template, which is the document assembly backend that produces the documents, and an A to J guided interview. We teach them this A to J product in 2-hour sessions, 4 hours. Jessica does most of that work, and we find students are able to pick it up and do things pretty quickly then. All right, so that's a little bit about the justice problem, and a little bit about the educational perspective. Next slide. Well, we could talk about it. So these are the tasks in the course that we develop. We do this field observation, 20 hours is required. They do a scope document to help begin to understand how project planning works, a research memo, a storyboard, and then the technology is delivered. And out of this course, we've delivered maybe 30 guided interviews and document templates that have been used by legal aid in Illinois and North Carolina and Minnesota, on the Nez Perce Indian Reservation in Montana, in North Carolina, in Ohio. So we've had connections with a lot of different legal aid organizations in a variety of different subject matter areas. Next slide. All right, so this is about education. We're at a law school and we have to figure out why education matters. And to many sort of viewpoints, that's what this book is about. That's what this symposium issue is about. How do we validate that this belongs in a law school and it begins to make people ready for the practices that they're going to face? So we're going to hear from different perspectives from folks who have tried different kinds of things in this space through this morning and early afternoon. But from my point of view, and what Andrew and I suggest in the article, is that we get this deep dive into law procedure and heuristics that you've already heard from me, that we get exposure to policy and ethical issues raised by legal services delivery and technology, and there are unauthorized practice issues that we face, and you can hear sort of a very interesting perspective on that from Mark Lauritsen at the end of the session today. But there are others, issues about confidentiality, about practicing in the cloud, and so on and so forth. We think there are key competencies for the emerging law practice coming. There are e-lawyering, unbundling, Web 2.0 cloud practice. And then the area that we found that sort of grew in depth as we wrote the article was as we studied what we did and what students said to us in their final reports, is that they're learning teamwork. They're learning how to see the world through the eyes of somebody else. Empathy. The eyes of a client that didn't have the same educational background that they had. They're learning project management, how to have a beginning, a middle, and an end to a project, and to deliver it on time, and to report to their client and make things happen in a way that is professional and thorough and detailed. And perhaps that's the best thing that comes out of this. All right, next person. Let me introduce Judith Wagner.
Yes, sir.
And Judith, I mean, I wouldn't do justice. We're so delighted that you're here.
Thank you.
So tell us about yourself and your project.
Thank you. Good morning, everybody. Is this on? Is that on? Can you hear me? Okay.
David, is that on?
Good. I'm from University of North Carolina. I'm delighted to be part of this project. Next slide.
Give it a moment.
Got it? Okay. So I started to develop a course with a colleague at University of Cincinnati, Lou Billionis, the dean there, several years ago. We had both been on the faculty at UNC before he left for Cincinnati to become dean, and I had done work previously at the Carnegie Foundation for the Advancement of Teaching, working on their Educated Lawyers project. So I've been thinking for a very long time about the questions displayed there. That's kind of my quest. That's an effort to render Don Quixote. How do students learn? What do they learn? What don't they learn? Part of what the Carnegie study really highlighted is ways in which traditional teaching methodologies leaves gaps in what they learn, particularly focused on the question of transition between being a student to being a person who sees themselves as a professional, a practitioner. Often students are thinking about being students while they're within the schoolhouse doors, but it takes a mental leap to begin to see yourself actually operating within the profession. And we, I think, need to give more support as people make that transition. How do you address these things within the curriculum? I think we've had a growing number of efforts that are extracurricular, professionalism programs, counseling by career services, but we haven't really brought it within the heart of what we do. Next slide, please. So really can think about models of legal education. The one on your left is traditional, thinking like a lawyer. If you want to know more about what I think on that, read an article at length that I wrote in Rutgers. law review. We do a lot with what Carnegie would call the cognitive apprenticeship, thinking processes, taking people through systematic analysis and so forth. And we do a lot with law, different fields of law, what our specialties are in our courses. And we do a little bit, and I think more in clinical settings than others, but a little bit about what it means to be a lawyer. What this course, Becoming a Professional, has tried to do, working in part with the Center for Creative Leadership, a very thoughtful group based out of Greensboro, North Carolina, is to think about it from the other side of the bridge, what it is to be a professional. And I think you can see some parallels here. To be happy, to find that sweet spot in the middle of the Venn diagram, you need to have a context that really kind of ignites you. You need a set of skills that allows you to really work within that space, and you need some level of passion. You see, I think if you think about this, that will speak to you as some of the realities of how we work. So the effort of this Becoming a Professional course is to use this model to get context, to provide a broader set of skills and get some passion. Next, please. So our first version of this course that has run now for 2 years has looked deeply at the legal profession, had students really doing a study about different fields of practice that they might be interested in, has tried to introduce them to a variety of soft skills, different formats for speaking, teamwork across distance, connecting students based in Cincinnati with those in North Carolina, talking about issues of how you work with people of different backgrounds and so forth, but really focused very heavily on questions of values and identity, hook the students up with practicing lawyers to probe some questions about what is it that really drives you and so forth. So we had collaboration built in because that's certainly something generally law schools haven't been doing enough of, and we assessed the students' work, again, a plug for assessment that you'll hear more about from others. Reflection essays on a variety of things, presentations both as teams and in solo settings. Principal projects were pro bono. Design a pro bono project that you would like to do when you're out in practice. Think about what it would take to do that. And I have to give credit, special credit to John Mayer, because back when I was on the Cali board and Barbara Glesner-Fines was chair of that board, John was either coming or going from his sabbatical that really ignited his work around A2J. So I was trying within my modest circumstances to think about how I might simulate something like that. Next slide, if you would. So what is it that we've done? As I said, I've covered most of these points on the left side, but cool projects that students did. One of the ones of the most recent crop was a student who is an immigrant to the States from Siberia, where his family had been because they were being persecuted in Russia. He developed a program to deliver and a brochure to deliver to Russian emigres who spoke primarily Russian about how they might want to rethink what the business forms were that they were using for things like construction businesses in order to be sure that they had appropriate protection for liability. Developing a website that would connect information about benefits for veterans, military personnel of various sorts. One who piloted A2J for me, a student who is the head of our Lambda group and has worked on issues facing transgendered people, about how you get your driver's license and passport to have your new gender and your new name. And then what I would describe as low bono, I think some of you know that term, less expensive, not for the poorest of the poor, but people who need services, how you could set up a low-profit effort to deal with the needs of people with securities fraud. Next. So now with A2J, some shifts here, new partners. In the past, the design of the course has had each of the two of us, Lou Biliotis in Cincinnati and me in North Carolina, having a practitioner or judge partner in teaching to really say we're talking about partnership and to make that real. This time it's going to be one of the folks from North Carolina Legal Services. There's a team of 3 that are working with us from there, one of whom will be sitting in class each session. New options for projects. I've met with them. They identify their top 5 priorities of things they would like to have addressed: recovery of personal property, security deposits, car repair claims, relief from collateral consequences of criminal charges that have been expunged, and then cease and desist for debt collectors. So I'm hoping I'm going to get teams of students on each of those tasks in lieu of the pro bono projects that I did previously. I'm not going to require every student to do an A to J version, but instead will provide that as an option. And I think because it's sometimes hard for them to galvanize themselves and to crystallize their projects, this will be a good approach. And May tried, the legal services people said that there would be real benefit to them if students could be videoed giving a plain English explanation of the area of law in which they're working. The opportunities and challenges, I think you can see there, I think we'll get a lot out of it, concrete options for the students to really take something from beginning to end in a very focused way. New skills we've been working on, but I think there's ways that this approach, this set of tasks will really sharpen what they learn. I'm very interested in the assessment consequences of this, to be able to show from the beginning to the end what they've gained. Also hope that I explore, we have a very active pro bono network in North Carolina, and I'd like to think if we can pilot this and possibly move it to some other schools, we might be able to really address the justice gap. I also hope this will be an opportunity. I have taught in our clinic the last 5 or 6 years. I'm not doing that this year because I'm doing this instead. I'd like to be part of the effort to get these possibilities out before faculty who aren't necessarily involved in the clinic, because I think there's a lot of ways that students can learn from this. I teach property. I'd like to have them be in the client role, walking through some of the stuff we might create, because I think that that will really animate them to be better lawyers. Last slide. That's it.
Greg and Sunrise, you want to just step up or sit, whichever your
This is
preference.
Greg and this is Sunrise.
Right.
We're using the mic, not just for amplification, but also for effective recording and.
We got it.
All right. Good morning, everyone. My name is Sunrise Ayers. I'm going to be teaching Concordia's A2J clinic, which we're actually building from ground zero. We're going to be creating this clinic around this project. So we're starting from scratch, which is exciting.
And I'm Greg Sergienko. I'm the academic dean. So Sunrise comes from a legal services perspective. She'll actually be teaching the course. And I think this is a great opportunity, but I've got a couple questions. First question, next slide. What are the challenges in delivering legal aid in Idaho?
Thank you. So I do come from a legal services background. I work at Idaho Legal Aid, which is the only free civil legal services provider in our entire state. And we only have the equivalent of 15 attorneys covering the entire state of Idaho. So not only do we have very limited free civil legal aid attorneys available for our population, just in general, Idaho has the 5th lowest number of per capita attorneys. So we also have a low number of attorneys per capita that we're dealing with. And we're dealing with the fact that our citizens in Idaho are spread out across the state in rural areas where it can be difficult for them to contact an attorney at all, get to meetings with attorneys, and especially if they have a sort of specialized legal need, like Medicaid for long-term care, it can be really difficult for them to get to an attorney who specializes and has the knowledge in that area that they need. So our vision for this project is that we have 3 outcomes that we're trying to sort of gear towards when we're building the clinic. And the structure of the clinic is that we're going to start with field work, where the students will be out at our legal aid office, at our court assistance office. There's a homeless clinic that we hopefully can work with them as well. So they're going to start with that. Then there's going to be some in-class delving into the substantive areas of law and elder law, and then the A2J forms. And so the 3 outcomes we're shooting for are knowledge, passion, and tangible products. The first outcome is increasing knowledge, and specifically we want to teach students how to effectively use A2J and hot docs in the legal practice, and how to fit those technologies into the practice of law, so that if they're in public service work, obviously that fits, but even if they're in private work, how to fit that into maybe provide lower cost services. How to do a legal needs assessment is going to be a part of our clinic. How to do the basics of a client interview, and how to use cultural competency when you're doing client interviews. And then how to basically get that preliminary understanding of some of those areas of elder law that they'll need to figure out what forms they want to pursue. So, Greg, how do these goals fit with Concordia's goals?
Concordia as a university is committed to public service. The university, which has a main campus in Portland, has won all sorts of awards for its public service. And not only for its own sake, but also because it aligns with the general missions of the university. We want to continue that. So we have extensive pro bono work, and this will fit very nicely into that. So we're very happy about the public service, but in addition, there's the educational outcomes for us. It's not just a problem providing good legal services for poor people. When I was in practice, couldn't have afforded myself. Probably most of us couldn't have afforded ourselves. And the middle class has problems too. Even general counsels at Fortune 500 companies are complaining about their legal bills. So we see this as a chance for students to develop a key skill set, making legal practice more efficient with document automation. And once they get this, if they go spend a life doing legal services, that is wonderful. Even if they don't, this is stuff that they can use to help regular non-legal services lawyers deliver legal services to moderate income people, even wealthy people. We need to fix this problem as a legal profession, and I see this as a key part of that. And that brings me to my second question. We talked about the hard skills they'll get out. What is your other part of the vision for this course?
Thanks, Greg. So the second part of our vision, next slide, is building student passion, which I was excited to see that in the last presentation as well. So in my experience as a new attorney at Idaho Legal Aid, I think a lot of us are coming from a place of relative privilege. And so I was thrown in the first day, had to start taking clients the very first day I started, never having visited a homeless shelter, a domestic violence shelter, an Alzheimer's unit in a long-term care place. So I think that's the place where a lot of our students will be coming from as well. And so the most important part of building passion will be the field work. We'll be getting them out, meeting with low-income and less privileged populations so that they are, so that they're getting to do these, they're going to be doing these interviews and that they build during their needs assessment to find out what legal challenges these folks are facing every day. That with no experience coming from, even when I first started, I did not have that understanding of, and that's an understanding we want to build in the students. The other thing that we'll be working on is with some of the readings and with the needs assessment process, giving the students an understanding of the systemic barriers that our low-income folks are facing so that they have a sort of broader understanding of what's creating this gap, this justice gap that we're trying to fix. And then one of the classes we are going to talk about cultural competencies and also have a frank discussion if they have any concerns or any preconceived notions that they're coming in with what it will be like dealing with homeless populations or persons with disabilities to get that discussion going so that they feel completely comfortable the first time they have to walk into a homeless clinic or, yeah.
Go fast.
Okay, sorry. And then the end result, of course, will be, hopefully, that once they finish the course, they have developed, through this understanding and through the field work, a lifelong passion for public interest and hopefully pro bono work because Idaho has a really low pro bono participation rate right now. So Greg, one of your particular areas of expertise is improving and engaging student learning. So I'd like to have you speak more about that.
Next slide, please. So the question is, how do you assess passion? And Barbara Glesner-Vines made a great point in a presentation yesterday. Grading is not assessment. If we ask students to display passion for a grade, they'll make it. So we're not going to make passion part of the grade. I don't even think we're going to ask them about it. If they tell us, great, but we may do a survey after the course that will be anonymous and say, how has this changed your attitudes? And that way they don't have to tell Sunrise, I still hate poor people. That would be an outcome that we would want to know about, but that we could understand that a student would have a hard time delivering. So, we'll do this anonymously. The other thing is assessing students. We'd like to know their passion, but what we really want to see is how this course is making a difference, and we can wait for that. We are going to track our students and see how much they engage in pro bono activities. Do they take legal services jobs? And we're going to do this for all our students. So, if we find out that our students who take this course do that more, that will be very helpful to us. It won't be dispositive, we may have a selection effect, but it'll let us know. So that's what we're going to do for figuring out how much of a difference this course is making. We've talked about the course, we've talked about students, we've left one bunch out, the clients. What are we actually doing for clients?
Great, last slide. So I'm going to go fast.
Okay.
So our final goal, of course, is tangible products that are going to be dispersed and help our client communities. We're going to have the A2J forums at the end of the clinic that will increase our Idaho citizens' access to justice. The forms we're going to be doing will be in the areas of elder law, likely involving Medicaid eligibility, advance directives, wills, guardianship, whatever the students identify when they're doing their interviews and needs assessment. And so through this, we can then put those forms on Idaho Legal Aid's website, and people who could not have access to an attorney will have access to these forms, and we'll be able to track how many people use the forms through Idaho Legal Aid's website, and we have therefore helped the client community throughout Idaho.
That's it, thanks.
Very good.
So as a lead-in to Richard Granite, who is going to do something a little bit different, a little thank you to Sunrise and her program, which is the partner, Idaho Legal Aid is the partner for Cali and Chicago-Kent, a whole series of these grants from the Legal Services Corporation. So thank you, and Mary Zimmerman and all your colleagues for that. And a shout out, right? So Idaho, on a per capita basis, does more A to J guided interviews and hot docs templates for low-income people than any other place in the world. Now, why did that happen? They had an early partnership between the judiciary and Sunrise's program. A judge named Michael Denard got excited about this idea because of all the rural need in Idaho and this constraint, 15 lawyers covering an enormous state the size of France. Decided that this was a way to go, and Michael led this charge. He took it to the judges across the country, established a unit in the judiciary that hired somebody to do this, and so done a great service to the country and to this whole area by partnering and leading in this way. So Richard, something completely different?
Completely different.
All right, completely different.
Use the mic, Richard.
Hi, good morning, everybody.
Good
You
morning.
didn't introduce me, did you? That's okay, I'll introduce myself.
Let me think. No, I didn't. No.
Okay, that's all. All right, so one of the roles that I had is to introduce this. It's co-chair of what's known as the e-learning task force of the ABA. The other co-chair is Mark Lawrenson, my colleague who's sitting right here. And we started this task force, was presidentially appointed in 2000. It's like 13 years later.
Started right here,
Started in Chicago, Kent, I was involved.
10th floor.
And we actually did a working paper. One of the charges was to get law schools to teach law technology and practice management, and to help lawyers figure out ways to deliver legal services online. For a long period of time, this was really a very quiet area, except for the last 2 or 3 years that we've had this recession and this upheaval, and everybody's looking at online delivery of legal services. That's another way of gaining access to justice, as you'll be hearing really for the rest of the morning. So in that context, Will Hornsby, who also is presenting a paper, came up with an idea that we should identify those law schools that are emphasizing and making a commitment to teaching law students to be practice ready in technology and practice management, because that's what they're going to really need to be effective, particularly if they move into solo and general practice. So we have compiled a list of default schools and many of the schools that are here. We have 13 schools now on the list. The list now appears on my blog, which is eLearning Redux, R-E-D-U-X, but it's moving to the eLearning page on the ABA website. Now, we're not endorsing these schools, which we're not allowed to do. We're just kind of identifying schools that look interesting in making a commitment to technology and management. So if you want to get on the list, you got to pay attention to the rest of the presentations. And then, if you think you belong on the list, write a note, actually to John, who everybody's here. John's part of this group, and Ron. And then we're going to do some more criteria, and then we're going to publish it and log about it as a way of really pressuring the environment to think more about why these are really key competencies that every lawyer needs to have. It's not our U.S. News World Report list, but it's our own little thing, right? So, all right, so with that said, let's go to the next slide for a minute.
You got 2 minutes left.
No, you can be 6.
What are you used for?
I'll go fast. Okay, so here we go. So what do lawyers know? We know law schools do a really good job of teaching the law. But they do a very marginal job about the other things that we're really talking about today. And the personal story is I run a company. Well, first of all, I used to teach law practice management at University of Maryland Law School and computer applications of the law around 1999 as an adjunct. I couldn't get the attention of the faculty. I actually had brought in about $500,000 worth of grants. The regular faculty didn't pay attention to me, so I quit and started a web company. And then a couple of years ago, I started this other company which provides a virtual law firm platform for law firms, which is actually a leading company. And I said direct law. It's called Virtual Lawyering Made Easy, or Made Simple. That was really a dumb thing because it wasn't so simple, it turns out. And I talk to lawyers every day. And it's remarkable to me what they don't know. It's like a bell-shaped curve. There's only 5% who really get it. 5% are irredeemable. And the people in the middle of the curve really don't know anything about what I'm talking about. And therefore, they don't stay with our program. So we have this high churn rate. We pick it up, and anyway. So I have to really educate the whole legal profession and the stuff that I'm interested in and what they really need to be effective. I'm talking about solos and GPs now, people who are serving the broad middle class. So the only way to do that is really to increase reach. Even though Mark and I do outreach at law schools almost every quarter when we meet, it's really not enough. So we really feel that we have to develop the kind of stuff that you're hearing about today. Next slide. So the question is, what is law school for? What's it been for? We know that it's been for now training lawyers to work in large firms, become Supreme Court clerks, to become professors. That's pretty much what the curriculum has been oriented to, except in the clinics. Next slide. So you pass the bar. Next slide. I'm going to move on. And no jobs. What we find is that law schools today, particularly second, third, and fourth tier law schools, the folks that are going to come out are going to end up working in solo and general practice, but they're really not prepared to do that. So there's a real big disconnect. 80% of America still can't afford a lawyer. Next slide. And this is the kind of things that you heard yesterday, you'll hear again today, what law schools really are not doing. You can read the article to get more details. I'm not going to go through that, right? What law schools should be training law students to do, because most of them are going to end up spending their lives in a solo or GP practice, a small firm practice. It's to really be practice ready. And begin to think about a whole set of issues. Bundling legal services, next slide, so that they can really penetrate what we call this latent market for legal services. The disconnect is huge. You can't have a legal profession that doesn't serve 85% of the U.S. public. If it doesn't serve that, we're going to have seismic change. At some point, the system is going to crack. I'm talking about the regulatory system. We're going to have a different form of deregulation in the U.S. that's essentially opens up the system. The pressure for deregulation in the UK came from the government because of consumer access. And unless the profession changes, sometimes we're going to have that here as well. Meanwhile, we think that there are many markets here that can generate jobs for lawyers if they can figure out how to serve clients. Next slide. So I think of law school, frankly, not Harvard, Yale, and Columbia. Well, they could be a trade school too. But to think in terms of like a trade school, it's not only to think like a lawyer, it's how to do things like a lawyer. That's what law school should really be doing, in my view. It should be like a restaurant. That's why. I mean, when you learn how to run a restaurant, you think about all these things you have to know when you go to the Culinary Institute. They don't only teach you how to cook, they teach you all these other things that you really need to know how to run a restaurant. Next slide. However, we know that being law is not like running a restaurant. really very different. And the paradigm that I like is what Columbia uses, which is there's a high information component to law. So if you don't know how to manage, organize, generate, optimize the information component of the law, in my view, you're really not competent. Law is being transformed by the internet. Law practice management courses now taught at the law school are obsolete. They're usually taught by 65-year-old practitioner using JFIN, which was out of date about 30 years ago. It doesn't talk about virtual lawyering, doesn't talk about any of the things that we've been talking about today and tomorrow. Next slide. So we think that law practice management and the application of law practice technology are in fact key competencies. We know, of course, you've heard that the ABA has now amended the definition of the competency of a lawyer so that lawyers have to appreciate the risks and benefits of technology in terms of understanding what it means to be competent. So we've had that in the new standard, but it's not quite enough. These competencies have to be really ingrained, and almost should be, I hate to say it, required courses. Otherwise, when law students get out, it's not going to work for anybody else or do that for 6 or 8 months. They just can't make it. They can't make this prescription failure. Next slide. So I think of law practice management as newly taught as legal process engineering, figuring out how to define a niche, figuring out how to define a new kind of legal service. You know, when we have these areas of these times of real depression and recession, this is a time for creativity. When people change their jobs, it spurs people to become entrepreneurial. And that's what we really need, new kinds of services that reach out to people in new and innovative ways. Next slide. My colleague who's not here has written the key books, Stephanie Kimbrough, in this area, one on legal scope representation, one on virtual law practice. Next slide. And a new one she came out with on the consumer law revolution. They're all published by the Law Practice Management section. I recommend reading them in terms of coming up to speed on these concepts. Next slide. So here's where we are. I think the profession is right here. Hasn't really evolved. Every other service industry has a client portal. When you sign on to your bank or your brokerage firm or your travel agency, you're signing on to a client portal. The numbers of law firms, solos and small firms that really even know what a client portal is, it's probably less than 1%. That's just an indication of a whole set of data that we have, which tells me that we're really, that we're really here. Next slide. And we need to catch up. We need to catch up for the reasons that I argued before, that you can't have a profession that's only serving the top 10 to 15%, either wealthy people, large corporations, or large organizations. It's got to serve everybody. It has to be 100% access. Next slide. And then we have the turkey metaphor. You probably heard about this one, right? Turkeys are really fat, and there are no turkeys in this room, by the way. You people are all leaders, I think, in your space, in your law school. So the turkey gets fed, and he's really happy, and he thinks he has a great life. And then about November 3rd, so I think that we have lots of faculty, lots of lawyers who are turkeys. They don't get it, and lawsuits, so they're going to end up. Next one.
What's going to happen to your time here?
That's it. So you have to lead. You can't. One way is a dead end for the profession. You can't really follow. And I think that the people that I talk to, this is a great group. This is a catalytic group that can go out and provide leadership in your law schools and try and prevent them from all being turkeys.
All right, so we're John LaFailure. We can't control these brilliant people. They all went over their 6 minutes, including us, right? So, but we do have, with all that effort, we preserved 10 minutes for discussion and questions and interaction with you. So, what do you have to say? They're all turkey.
Gobble, gobble, right?
Questions, thoughts, reactions? Told you we talk amongst ourselves if we don't get something. You believe this?
Some of it looks a little familiar, some of it is very inspiring. And when I say it looks a little familiar, it doesn't mean...
Just because you've been to every Cali conference in the history of the world.
Yeah. familiar in the sense of validating stuff we're trying to do.
Talk a little bit into the mic so that we can catch this and send it out to the world.
Ken Hirsch at Cincinnati.
Hey, thanks, Ken.
It's good to see a lot of this which is new to me and is inspiring. It is also good to see some of the stuff Richard was just talking about, which is validating. For example, we added work on a client portal to our tech and legal practice class this past semester.
So Cincinnati's way ahead. They were working with Judith in that professions course, right? The dean there for years. But anybody else have this going on that we don't know about? Bill Boyd. Bill, I think you're too old to come to these kind of things, you know?
Right.
Haven't you retired like 10 years ago?
20. But I still think about these issues, and so I'll just direct my question to you, Ron. I mean, we all sit around wringing our hands and agreeing with Granite's assessment. How do we make it happen? I mean, what's going to change the law schools? My view is that economics are going to impact what law deans and faculty do, but it's a tough path to get anything to happen.
Well, I have an agenda. I have a hope, right? And one of them is that we can take the kind of course that sort of combines these skill sets and these deep looks at law and get every law school to teach them. And I think it has an educational impact and a justice impact. And I also think that it addresses Richard's point, because I think it teaches law practice management and the kinds of things that the incubators are beginning to bring to the new law graduates as ways to help them get started. So we have an incubator here, and Cook County has another one, and there are about 10 or 12 of those happening, post-grad kind of approaches to this. But I'm not thinking that we're hand-wringers here, right? I'm not. And I think we're people out trying to do stuff. The question is that you have this big bulk of faculty members who have been teaching the same way, their Article 9 course like the same way since like 1942, right?
Not quite.
Yes, tell me your name.
Jan Stone.
Hi, Jan.
My question is, your class that you teach is an upper level class, is that
Yeah.
right? Is there anything you could do with this practically in a second semester, first year class?
All right, so all of us are doing these sort of curriculum committees to react to the crisis and so on and so forth. So we had this all-day curriculum committee, which was the whole faculty. Let's all get together. We went to a restaurant so we couldn't hear each other when we talked instead of in a classroom. It worked out really well. So the whole faculty is thinking about this here, and I'm sure that's happening everywhere, right? Everybody's trying to say, what can we do to be better, to be more responsive, to compete with each other more effectively, and so on and so forth. And the question that after some of the drafts of our article was circulated among many members of our faculty, that came from that committee to me was, can you do that course for everybody in the first year? Can you have everybody go through an opportunity to get some of the empathy that Sunrise is talking about and have some experience with other cultures, to see these technologies, to prepare, and all those, and I don't know, I think I can.
We're doing it as a second year course, first semester, second year, and I don't really see a problem moving it up another semester. You have to coordinate with what's being taught in the first year, in the first semester, so that they have usable chunks of knowledge, but I don't think it would be a problem.
Well, I mean, I'm sure you can do it at any point in the period. So there's two questions you're asking. One is, can you do it earlier? And the answer, sure. Second question is can you scale it? You know, I teach 10 or 12 or 15 students, and I have a lot of help. I have Jessica and Andrew, and I have another research assistant. I can just sort of like push it down the hill and walk away and go play golf, and it'll be just fine, right? But so there's a lot of resources on those 10 or 12 people, right? But I think we've done here before teaching everybody how to do word processing and 8 hours in orientation. I think you can push this up earlier. We can teach things more quickly and more efficiently. Yes, tell me your name.
I'm Doug Edmonds from the University of North Carolina School of Law, and at the risk of embarrassing my friend and colleague Judith up there, a couple of years ago, with the Director of Technical Services in our law library, I'm the Assistant Dean for IT at the law school, but I was surprised that we didn't have like an LPT course, and we floated it up, wrote a syllabus, wrote a course proposal, because there's been a real push, as in many curricula, to do more practical skills training courses. Theory to practice sorts of courses, and we floated a course proposal. It was approved by the Academic Affairs Committee, and then in the next breath they're like, but we're not going to let you teach it anytime soon. There's too many of these other practical skills courses that are frankly more important to the faculty, and we're being taught by tenure track faculty, and neither Steve nor I are tenure track faculty. So I totally understood that. I was also disappointed because since then, that was I think in the fall of 2011, that the course got approved, and there's been no mention from the Dean of Academic Affairs since then that we could maybe teach it at some point. So, I don't know, maybe Judith and I should talk to the Dean about that, but
there's a new associate dean.
yeah, that's true, that's true. So, we're making efforts, but I think, again, there's some resistance, or just for practical or logistical reasons, sometimes it's hard to get it going.
I mean, I think if there's a time we can do this, it's now. I mean, you take John's opening slide about Rahm Emanuel. I mean, this is the crisis time. If we can't push our way into this arena with relevant, excellent education that addresses substance and procedure and heuristics and the need to deal with the core competencies that the Carnegie Commission identified, I mean, if we can't do it now, we can never do it. Now is the time. Yeah. Say hello.
I'm Karen Broncos from Rutgers School of Law in New York, and our clinics use a case management system called Amicus Attorney.
Say it again.
It's called Amicus Attorney.
Amicus, yes.
Case management system. And my question is, do you think those types of programs actually are useful in evolving the legal practice, or do they just automate turkey-like behavior?
So Richard is our law practice management advocate and expert.
Okay, so programs like Amicus Attorney really automate the back office functions of a law firm, like Hutkin billing, calendaring, and things like that, which are not, those are pretty easy to learn in a way. What we're talking about are other kinds of software applications, which is legal work. Document automation, expert systems, ways of dealing with clients, giving legal advice by SMS, legal advice systems. Everything that we're talking about has an intersection between technology and law. And to create those things, they're rigorous, it's intellectually demanding, requires really analytical skills. Back office applications will change, technology will change, even the front office applications will change. My front office, I'm talking about, if you ever read Susskind, it's the upper quadrant in his grid, which is where all the innovation takes place. It's the intersection of information technology and actual law, the digital legal services. And that should be at the heart of law school. If you think
Well, I agree with everything you said. The only thing I'd add, I got you just a second. The only thing I'd add is that I think if your clinic is not using something like that, then there's a problem, because how do you keep track of stuff, right? You have a bunch of individual practitioners who aren't really like managing their practices well. And managing your practice, even at that back office level, is an important set of skills, because especially if you're going into practice on your own, you got to have that stuff. So I wouldn't discount it in any way, but I think that you need that plus. You need more things.
I guess what I'm wondering is, can those software vendors play a role in taking the next step?
Well, if they're smart enough to come and give you this stuff and help you teach it.
There's one in the lobby right now.
Yeah. Clio is a good example. Clio is a web-based version of that kind of tool that might, we'll talk to them.
We make direct law available for free to law schools. You can just go right to the site. Students can sign on, and they can experience a virtual law firm. We actually include in our thing a document automation solution. And, there's a lot of things you can get for free, right?
Right, exactly. Yes, sir.
Sorry, I'm Michael Roback from the University of Missouri, Kansas City. We're I'm proposing a clinic in the spring. There's really going to be a clinic for the clinics, so that we can do things like have amicus, train people to use amicus, because, not to disagree, but there's some things about amicus that can help the clinic with its high turnover. You can embed rules, practice, management things that actually make training the students a little bit easier. But the students who learn how to build it are going to use other tools like Visio and things like that that help them understand data flow diagrams, how to do the legal engineering thing. So I think there's actually a place for all of that stuff. But for us, the other thing is, since we're so rich with solo and small practice in Kansas City, the idea of building a clinic that can be an outreach for law firms, and it could be a revenue source for the school. That's kind of what we're trying to build.
All right, so we're at the end of our time. So we started out today with, here's the big idea of this law, justice, lawyering initiative. And instead of like jumping right to clinics in the traditional way, we sort of gave you some hybrid examples. So Judith is in the clinic, taught in the clinic, but isn't her core teaching experience isn't clinic. I started in the clinic, and my core thing isn't, so I'm not teaching a traditional clinic. Sunrise is sort of teaching a little more traditional kind of clinic in Greg's environment. And Richard's, he's something completely different. So next session, right, we have a group of people who grew up and developed expertise and are known as traditional clinical faculty members in law schools in the country. And we hope that we can get them to sort of galvanize an initiative that gets lots of folks like them to do this. The reason we started out with hybrids is that there are more people who aren't them. And so if you want to carry this message back, you don't have to be a clinical teacher to teach a course that has experiential and practice and fieldwork aspects to it. You can do it right from the classroom. And so there's opportunity there too. So let's talk amongst ourselves with some coffee. And do you have something else out there? Some donuts or something?
I hope so.
Okay.